we will be able to have a go at answering that question. And I just thought while we're doing this session is being recorded, and we are also streaming live on YouTube. So if you have a problem, speak now, leave, or forever hold your peace. And when I say speak, I again mean in the chat box.
Romain, how's it looking? I think you got the right camera.
Pardon?
I think you had the right camera, but now the video stopped again.
My video stopped because everybody's frozen now.
Yeah.
I don't know what to do with that.
Before we start.
It's frozen now. My video stopped because
maybe just turn video off and on again, or sign out and on again.
Can't you see me now?
No.
Weird.
Yes, I can see you. And
now
you're
it's
moving.
coming. Yeah. Yeah, now you're showing. And we can hear you. Perfect. Let's not change anything. So shall we get started, Raphael?
Yes. All right. So welcome, everyone. Good evening. Good morning to some of you in other parts of the world. I'm joining in from Mumbai. And this is the BGS 2020 Roundtable on Schrems 2, regarding the EU-US data processing without shield. That's the discussion we're going to be engaging in today. We've got some amazing panelists right here. You can, their videos on, you can see them, and they'll wave out to you. I'd like to, at this point, remind you of two important things. One is that this session is being recorded for archival purposes. We may be sharing snippets of the session on social media at later points. This is also being streamed live on YouTube and Facebook, I believe. So you can tell your friends and family to catch us there and wave out or say hello to us in the chat box. The next important thing that I'd like to mention is every speaker here, and we've got some fine stalwarts, mavericks, I would say. Every speaker is sharing their personal view. They're not representing a company or an organization when they speak here. And we're not providing legal advice, but we're discussing this topic. And might I say, this is something that really worries a lot of us on this call. But we're here to discuss this legal topic, put up views, and put up possible solutions, arguments, and opinions in an individual capacity. Without any further ado, I'd like to give us a general introduction into the session. And I'd start by saying this. If today you want to process EU data in the US, the GDPR demands essentially equivalent data protection rules. The European Commission said that the privacy shield was sufficient, but the ECJ disagreed and said the privacy shield is now invalid. We're at this unique juncture where a lot of us don't know what to do or what to make of it. And the question to begin with and take off on is, are legal data transfers still possible? If so, how? And that's how we'd begin, and I'd like to get into it. Before that, we've got, as I mentioned, some stalwarts in the data protection and privacy regime with us here today. And I'd like to I'd like to take this opportunity to introduce them with their name and title, and then allow them to give us a brief bio of themselves and what they're currently doing. So to begin with, Dr. Anna Zeiter, Chief Privacy Officer of eBay, that's her current title. Dr. Anna, if you would give our viewers a introduction.
Thank you for the invite. It's a pleasure to be here today. So my name is Anna Zeiter. I'm eBay's Global Chief Privacy Officer and also eBay's Data Protection Officer. I'm a German lawyer by training. I worked a couple of years in Germany in big law. Then I moved to the US for an LLM program, not at Berkeley, a couple of miles more south, but I'm friends with a lot of you guys, so happy to be here today. I'm with eBay since 6 years. I've seen 5 years ago Schrems 1, and now I see Schrems 2. So happy to be here today and share my experiences with you.
Glad to have you here, and thank you for making out the time of your busy schedule. I'm sure you must be getting fielded millions of questions at this point. Our next speaker is Mr. Daniel Mellin. He's a cloud and data center strategist at the Swedish tax agency. Daniel, over to you.
Thank you. So my background at the current state, I'm doing strategy stuff for data center and cloud things at the tax agency. But that's a quite new thing for me. Before that, I'd done public procurement for like 11 years. And a lot of that was cloud related. We did the first framework agreement for the Swedish public sector in 2012. So I've been studying how the public sector could use cloud services, how data privacy could be protected when using cloud services for about 8 years now. So that's sort of my main topic. I also want to sort of add that I'm not any legal scholar by training. I'm an engineer. So bear with me that I don't know all the legal stuff by heart. I will sort of try to take this from a more practical perspective and what it could mean for a customer of these services.
That's great. We are looking for practical solutions here. I don't believe legal minds can solve all the problems in the world. I don't believe that at all. That's a great segue into our next speaker, Romain Robert, who's the senior data protection lawyer at Noib.
Hello, thanks for the invitation. Just briefly, I just joined Noib 3 months ago. I used to do data protection for many years. I used to do data protection in a law firm in Brussels, where I qualified. I therefore, after joined the Belgian DPA, then the EDPS, and then the EDPB, and decided to join Noib 3 months ago.
Great, thanks for joining us today, Romain. And last but not the least, speaker. If you're wondering how I'm so conversant in privacy terms today, is due to this man and his crash course on Schrems 2 with me, Mr. Dennis G. Jansen, who specializes in technology, data protection, intellectual property rights, and software. Dennis.
Thank you, Raphael. Yes, it's a pleasure to be here. I'm also a BGS member, by the way, and I work as attorney. I work as general counsel for Coach Hub, which I'm not representing here, and despite the background maybe. And I founded my own startup in digital forensics, and I've been working for the last 2 years in developments regarding Cloud Act and sort of the foreboding of Schrems 2. I've been looking into it, and yes, so I'm really excited to be here and discuss with all of you where we go from here now.
I think I think we should begin with the first question that I have. And although I'm sitting in Mumbai, what's happening in Europe or what's happening between Europe and the US is quite relevant to us. And I'll give you one reason why. When on 25th of May, 2018, that's when Oba and I were in Berkeley, that day, the rupee versus the dollar, the rupee went up 2 points versus the dollar. And I think all of you can guess why, because we're processing a lot of that data, and we're doing a lot of that compliance work here in India. And so I have a vested interest in this discussion. But to begin with, my first question to you, maybe Dennis, is will SCCs still work for the US?
Wonderful entry question. Probably one of the easiest questions you could have asked. No, not really. But yes, will they work? I guess it's also the question for which purpose and which context. You know, it's the typical, the favorite German lawyer's answer is it depends, and I would start with that. I would say that as a first measure to improve compliance, and especially for companies which only had privacy shields so far, I think it would definitely be an improvement, and it would probably work for that to try to at least get something in place. I don't necessarily believe it will be able to legalize in light of Schrems 2 data processing in many cases, at least with the figure S.
And Anna, I'd like to point that same question at you as well.
Yeah, I mean, that's the big question, right? So, I mean, from a company perspective, I would say let's approach that with a bit of a formalistic standpoint. So it's still valid, right? So Schrems 2 only formally invalidated the privacy shield. So from a company perspective, I would say standard contractual clauses and binding corporate rules are still valid. So that work with that. And let's try to make that as compliant as possible for the interim, because I think we all know that this is something that needs to be solved on a political level. And I have the impression in the meantime, companies can do some mitigation measures to win time. And we all hope that there will be a political solution rather sooner than later. Maybe to give you a bit of background, so eBay is mainly relying on binding corporate rules. So eBay has binding corporate rules already in place since 2009, actually as the first Silicon Valley entity. So that's pretty cool. And we use this mechanism to transfer all our data internally across the globe, which means we have globally already European privacy standards within the company. So that means whenever we buy a new company, we have to make sure that they also will be added to this mechanism. That means that we implemented GDPR also globally at eBay because we have to adhere to European privacy standards globally, which means we are already in kind of a good situation because our internal data flows are covered. But of course, the data flows to third parties like third-party providers in the US, in India, in China. They are of course impacted, and especially those whenever we use service providers in the US. I think, I mean, for now, I would formally say standard contractual clauses and the binding corporate rules are still valid. So this is what I see black and white. Of course, I'm not stupid, but I mean, I would use that for now. And maybe later, I don't want to take too much time right now. Maybe I can tell you later what we would do as the next step to make that as compliant as possible. But for now, I would say they're valid. I have a formalistic view, and let's hope for a political solution soon.
Well, that answers my second question, which was going to be about alternative protections, and you've effectively answered that with regards to BCRs. Let me point this a part of this question at Romain. When you will SCCs work for telecommunications providers according to, let's say, an act like FISA?
No. The answer is simple. I think there is no need to develop on that. I agree that of course, I think we all know the elephant in the room. The court said that the SCC did not invalidate the BCRs and the SCC for sure. But if you make a not even a careful reading of the judgment, you can also see what the court said and what the court wanted to say without saying it. Because I hear a lot of people saying, oh, if the court wanted to invalidate the BCRs and the SEC for the US, the court would have said it explicitly. I think when you're quite used to the way the Court of Justice hold the judgments, you know that the Court of Justice never explicitly say what she wants to say, what the court wants to say. You don't have to read between the lines, because here it's not between the lines, but I think it's quite clear that first, the privacy shield is invalidated, but for specific reasons. And these reasons are that the guarantees in the US are not compliant, not with the GDPR, but with the Charter of the Fundamental Right of the EU, which is not the same standard. It's a higher standard. So it means that you can try whatever you want to try to achieve the same standard of protection that the GDPR. You can use BCRs or SEC. It's still not going to be enough, according to the judgment of the court, since, for example, there is no judicial redress in the US, and I don't see how a standard clause that you sign between an EU exporter and a US importer might create a judicial redress in the US and change the constitution. So far, I don't think that you can change the US constitution by signing a contract between two companies from both sides of the Atlantic. But that's already a nice development of the discussion that we're going to have, I guess. But the answer to this question, STC are valid, yes. Can they be used in the US? The answer is no.
Okay, wow. We're really getting into the thick of it here. But Daniel, your comments on this, what do you foresee as alternative protections, and how have alternative protections like BCRs been affected in this scenario?
First off, I think the easy way is to go, I think, in steps, to first look at wherever you use Privacy Shield and stop using those services unless they can provide some additional measures or means or move the service or whatever. But if it's an American service and the only base they use is Privacy Shield, and that is not going to change, my view is that you have to stop using that service. And next up will be, of course, the SSEs. In most regards, I agree with Romain, but I see a lot of issues with sort of the area where my area, sort of my view is a bit narrow though, because I'm looking at it from like an ISP, from a cloud provider standpoint, and not every, because you have all kinds of companies, of course, that moves all kinds of data, but I'm not sort of very versed in those areas of business. But looking at like a cloud provider that wants to sell a service to, in my case, a Swedish public agency. So what are they going to do? They are, of course, hit by the FISA 702. A lot of them states that clearly on their websites, and they say how many FISA requests they get. So it's not an issue if FISA 702 hits that kind of companies at all, because they say it. And since I think it's quite clear in the judgment from the ECJ that is an issue with the FISA requests. And since you don't really know, as far as I've seen, that what the FISA requests are, sort of what they are asking the suppliers for, what kind of data, how much data. So you're dealing with if you're doing like math, you're dealing with something that is unknown. And in this case, I see that's really the issue that I have. It's so hard as a practitioner to deal with something that is unknown. So in that sense, my next view would be that SECs and cloud providers and other communication providers that are affected by FISA 702, I think they won't work. I have a hard time seeing that. And then the next steps are BCRs, of course, but I don't really see how BCRs work either. They have, of course, again, depending on the type of business you're doing, what kind of data you're moving, and how your protections are. BCRs is, of course, the best way to do it in the current state. But I see a lot of the issues that SSEs have are shared with BCRs, even though BCRs are not mentioned by the ECJ.
Right. So I'm already sensing on the first topic we a slight difference in opinion, if I may say, or difference in approach to this problem, or maybe that's a matter of perspective. We have a question in the chat box regarding the new SEC that was developed after consultation by the law firm Timelex in the spring of 2019. Maybe you can go through that question in the chat box, and we can get at it later. But I just thought I'd highlight it for you. The next question I have is: will there be third adequacy decision will there be a third adequacy decision for the USFA? And maybe we start with Anna.
Actually, maybe could we? I would love to comment on the other measures as well. Which
me too, actually. So Dennis, please go ahead. I'm writing down some comments. Please go ahead.
Excellent. So I'm thinking, yes, I pretty much agree with. I feel like I agree a lot with all the speakers, to be honest. I'd like to start with that, and I think like there's not necessarily such a huge difference in opinion, because I think everybody agrees that SECs are still valid formally, and I think even if data transfers to the US are not possible, I think everybody agrees that SECs would be better to just have Privacy Shield than having nothing right now, or BCRs. And it seems to me, that there's actually a huge agreement here, it seems to me. And then I also agree that probably to a large extent, I think BCRs are one of the best measures because they're sort of least directly impacted by the Schrems case right now. So kudos to you, and you know, a good job on preparing those, especially so early. You're very lucky, Anna. And then I believe, but generally, you know, for most cases, it will be difficult, or, you know, as Daniel said, if you have FISA section 702 applying, it's probably going to be a problem to use them. And yeah, we could be pretty formalistic and say they're going to be valid until they're suspended by a supervisory authority, for example, or data controller. But I think they will also mute yourself. And
that's perfect. That's perfect.
So I think they will actually eventually face the same or similar issues, at least, and we will have to see on that. Ireland said they face the same pretty clearly. We'll see, and I'm looking forward to EDPB guidance, especially on this point.
Yeah, me too. I would like to add on that. I have the impression we have a problem here that cannot be solved by companies.
Perfect. Thank
The
you.
problem is, I mean, it's actually a fundamental clash of laws. GDPR on the one hand, and on the other hand, we have the US surveillance laws. They don't match. There's a clash. And I have right now the impression that everyone is looking at the companies like, haha, how do you solve that? And I'm like, I cannot solve this clash of systems. I cannot. I can only do whatever is in my hands to mitigate, to try to show to regulators good effort. Maybe we would do a contractual review, like what kind of SCCs do we have? Can we add?
Anna, sorry, just a second.
Can you mute that person?
Yeah, Hema, could you mute Sensor Pro, or if you could mute yourself, Sensor Pro? It's a bit of a sensitive topic that we're talking about right now, and we're in the thick of it.
No problem.
Yeah. All right.
Oh, thank you. So once again, I think this is a clash of laws, and everyone is now looking at the companies like, how do you deal with the situation? And I'm like, yeah, I cannot solve this political problem. I mean, I can talk to my governmental relations teams in the company, on this and on that side of the Atlantic Ocean and tell them, hey, please make sure that whatever you can do to find a political solution would be great. In the meantime, I try to stick to my formalistic view, like DCRs are still valid and SCC's general also still valid. I mean, what we probably will do. So first I told my team, buy popcorn and wait. So because it doesn't make sense to do something now within the first week after the court ruling. So our approach is to wait 4 weeks and to see what the European Data Protection Board comes up with, you know, what our main regulator in Germany comes up with, to have a bit of an overview, because currently I see that the opinions of the data protection authority still go a bit, you know, sideways sometimes. And so I told my team, buy popcorn, wait 4 weeks. And mid of August, we would like to reconvene as a team and decide about the next steps. And I think the next steps will be, first, we need to do a contractual review to see, okay, these service providers in the US only rely on Privacy Shield. Okay, we have to sign additional standard contractual clauses. At the same time, probably we would do a review like which of the service providers is an electronic communication service provider. Maybe we add some additional language to the SCC saying, hey, whenever you receive a FISA request, please let us know. Then we have to reconsider. Maybe we do an internal data privacy impact assessment, like documenting our thinking, so that we have solid documents at hand. And in case our main authority in Europe would come, in Germany, we can say, look, this is what we have. We have the binding corporate rules. We carried out a contractual review. We have this privacy impact assessment. We added specific language to certain standard contractual clauses. We don't rely anymore on the Privacy Shield. And so this is my idea, to do whatever I can do as a company, and then try to, you know, help the governmental relationships teams in the US and in Europe to come up or to help facilitating a political solution.
Wow, that's great. Daniel, Roma, do you have any thought? Roma, yeah.
Yeah, just I agree with Anna, and I think I agree with Anna just used an euphemism to say that the DPO sometimes disagree with their statement, because you could see that last week they were totally going to opposite direction. It must be very difficult to be in a business right now. I totally agree. When you see the Berlin and Hamburg DPA thing already killing the SCC, basically to say you can't use the SCC to go to the US. And the commission the same day, and I was super surprised to hear Commissioner Jourova 2 hours after the judgment to say literally the SCC can still be used to go to the US. I think it's a crazy statement to say 2 hours after a judgment, when all the businesses and the EDPB are still thinking about a solution. You hear the commissioner having like agreed solutions. They say the SCC are still valid. Come on, let's wait a little bit. I think Anna is right. Buy popcorn and a lot, I think, because you will have to see what the EDPB is coming up with, and especially the DPAs. They apparently need to first agree, because they really seem to disagree a lot about what has to be done with the SCC, which just shows that it's not an easy task for everyone, not for the business and not for the regulators as well, because they are just faced with a very difficult solution. I think they get read the judgments as well, and they see the loopholes. They just see that there is a problem there, and the clash cannot be resolved by the business. It's super difficult. That's what I wanted to say. I had some other comments.
What about a timeline, Roma? Anna said she's going to reconvene with her team in about 4 weeks. How long do you think you'll be munching on popcorn for?
Actually, if you might have seen on the website of NOIC, we were not really eating popcorn. We're trying to provide not solutions, but to provide some tools to go and to use to try to understand the impact and the consequences of the judgment. Like just try to ask your providers what kind of legal basis they use for the transfer, trying to understand it, trying to use your right to have access to the DCRs, to have access to the SCC, and trying to understand on which basis the transfer took place. And I have a question as well for Anna, if I may.
Yeah, sure.
It doesn't mean to be provocative, but it would be interesting to see why, for example, eBay is transferring data to the US. What's the purpose for which the data are transferred to the US? And of course, you understand my question. Would it be a way to limit this transfer in a way and start from scratch by saying why these data are not in the first place staying in the EU and only sent to the US when necessary?
Okay, happy to answer that. But first I want to go back to one other point. So it's not that we are only munching popcorn for entire 4 weeks. Of course, we are munching popcorn and we observe the situation, and I talk to outside counsel. I talk to other DPOs, to other CPOs to get a sense of, you know, where is this entire story going? And I already heard some interesting news that, for example, DLA Piper is obviously developing a standard contractual clauses assessment tool. I don't know how they want to do that, but that sounds really interesting to me. So I think in a couple of weeks, we will see interesting things coming up like assessment tools. I mean, the OneTrust and trustees of this world, they will come up with other technical solutions. So I think we are munching popcorn and observing the market and observing the political situation. Now, Romain, coming to your point, why do we need to send data to the US? We are an international marketplace. So we offer, for example, that you from Austria could go to ebay.com and buy a pair of sneakers. So this is inherent of an international marketplace that you need to transfer data internationally. So it's first to facilitate the contract, to facilitate the transaction, we need to transfer data internationally. And not only within eBay to make sure that this server, you know, displays the website in the US and this server displays the website in Russia or in Germany or wherever. So this is inherent of an international marketplace that you need to transfer data internationally. Of course, I mean, we have big servers in the US, but we also have servers in Europe, several one actually. It's not that we only have data in the US, but since our headquarters is there, I mean, of course, we have more data there because we have also more developers in the US. And then, I mean, we really have to differentiate between the data flows. So first we have internal data flows, like employee information, for example. It's not so easy that we can say, oh, we silo the information. We have here the European employee information and there we have the US employee information. We are working in global teams. We use Zoom. We have to facilitate that. We work, I mean, my team, for example, we are 20 people working around the globe. It needs to be possible that we work together with, you know, electronic communication tools, and therefore we need international data transfers also from Europe to the US. Of course, as a company, I'm always keen to, you know, limit data flows or limit the privacy risk. Whenever we have, for example, discussions with a third-party provider, for example, in the US or somewhere else, and this third-party provider is able to offer the same services from Europe for the European business, of course, then I would say, oh, okay, that would reduce the privacy risk. Let's do that. But sometimes it's not so easy. Sometimes, you know, the offers from the US are better. It's, you know, more matching for the market. So of course, I mean, companies are already looking into that since 5 years, because since 5 years, we know that maybe international data transfers, especially from Europe to the US, might be at risk or are at risk. And now 5 years later, we saw, okay, that actually became true. Privacy Shield was not so stable as we thought or wished it would have been. But actually, it's not so easy. I mean, right now, maybe it's ironic, but this communication is only possible because we use Zoom, and Zoom relies on the Privacy Shield. So it's not so easy. And another point, we live currently in a pandemic. It's not so easy to travel and meet people in person. We have to rely on tools and communication tools, which also use or are based on international data transfers. So, I mean, trust me, we try everything to limit the privacy risk up front, but sometimes it's actually not so easy because of business constraints, because of, I mean, pragmatic constraints, and because of actually real life constraints.
Oh, that was a really robust answer, and I like the reference to Zoom as well. And in light of the pandemic, what you're saying makes a lot of sense. We can't do much face-to-face interactions and haggle on those dealings in person as we would normally do. But now maybe I could move on to the next question of will there be a third adequacy decision for the US of A? Maybe Dennis, you can kick off by answering this one.
Let me get out my crystal ball. I think it's mainly a political decision, of course. I think it's, if you look at the past and if you look at the main actor here, which is the European Commission or EU Commission, I believe it's, from that side, it's likely. I think they seem to be interested, despite maybe not seeing the problem with standard contextual clauses at all at this point. I believe they might be interested, but I think it might be very challenging and very difficult. Not only if you want to have a maybe longer lasting decision than safe harbor and privacy shield, which would be perfect, and it would be great if there would be like a change to US law to make it more in line with EU fundamental rights requirements. It would be, of course, wonderful. And then under that, in that context, I could see maybe a longer lasting solution. Yeah, I think it's quite possible that there will be another adequacy decision similar to the privacy shield and safe harbor. I don't know how long it will take right now in this context. I think the election might have an impact on that. I don't think something's going to happen before the election, because I think there are other issues which are more sort of central on both sides of the ocean, probably. Yeah, after that, I think the election may have an impact itself as well.
Maybe to add on that, I heard some rumors a couple of weeks ago that at one point California might apply for adequacy, because they say, okay, now we have CCPA, we would like to put on the ballot CPRA, which is even stricter than CCPA, in some instances even stricter than GDPR. So this might be something that we could see, that at one point California applies for that. And I don't know if this would be possible from a legal perspective, that a federal or that a state in the US applies for European adequacy, but that might be an interesting development. Yeah.
Yeah, Romain?
If I may, I think it's interesting. Of course, legally speaking, it's already provided in a GDPR, so you might have a territorial adequacy decision. Again, it's not really an application. I think it's interesting what you said, Anna, because you can see it in the GDPR. There is no procedure to obtain an adequacy decision. There is no application for a territory, and there is no decision from the Commission. You never know where and who is triggering this adequacy procedure. It's political negotiation. I don't know. We never know who is asking what in this adequacy, but it's another side note. I wanted to say about this third privacy shield. We might not be surprised, because the Commission already thought it was a nice idea to have a privacy shield, despite the very clear language of the Schrems once decision. Nobody can say that we can be surprised. I think we didn't want to read the decision of the first decision of the court entirely, and we didn't want to understand it. Commission apparently wanted to ignore the decision of the court, adopted a new privacy shield. Maybe the third one might be call it a data protection umbrella or an intimacy trampoline, whatever you want to call it. It's not going to fly. The title doesn't matter. As Anna just said, the Court of Justice made it clear that the surveillance system of the US has to be revised to be compliant with the Charter. It's not something that the EU can fix with another data protection umbrella or trampoline, whatever you want. It's not something that can be fixed by the EU legislator. The Court of Justice made it very difficult for the Commission to come up with a third decision that might comply with this basic rule. There is a lack of judicial redress. There is a lack of accessibility of the surveillance law in the US, and that's why that's why the privacy shield was invalidated. And I think, in my opinion, that's why the SCC will be very difficult to use, and the BCR as well, to comply with this fundamental charter. And there was also another issue that I would like to discuss, and that's also linked with the necessary transfer from eBay or from other businesses. what about the derogation of Article 49? They were mentioned by the court. Nobody's really talking about this derogation. The court just made a hint. I really think the court was like, hey guys, there is an article that you might use. I think, because again, we always say, oh, the court didn't say that. Oh, the court said something explicitly. Go and read Article 49. Why is everybody still focusing on a third privacy shield decision or on the BCR, the SCC? Apparently, there is like an open door by the court. Even if I agree that, what about judicial redress? There is still no judicial redress in the US if you use derogation. And what about the EDPB interpretation of this derogation? Because, you know, they have a very strict interpretation of this Article 49, since they consider that it cannot be used for massive and structural transfer to the US. But that's, again, an interpretation of the EDPB. Do we have to agree with that? I'm not sure, because you can also reread Article 49. There is nothing confirming that only be used in occasional transfers.
I absolutely agree with that. So this is why I have here my GDPR, and that was a bit my homework for today, to see, I mean, what can we do with Article 49? Is there something we can use more in the future? Some people say, we might need to rely on consent more, but consent is also a bit tricky because consent can be withdrawn. Imagine you ask users for consent that we can transfer their data to the US, they give consent, and half a year later they say, no, we want to withdraw the consent. So then we need to be able to withdraw these, or to stop these data transfers and rely on another mechanism for which we don't have another solution. So I think consent is a bit tricky. But I mean, for the performance of a contract could work. But I mean, I know that there has been an EDPB guidance which says that the scope of this exemption is not very broad. This is something where we probably might need to dig a bit more into and maybe challenge the opinion of the EDPB a bit. So I think this is the homework for the next week, to see what other options we have beside reviewing STCs, maybe add additional language, check if the service providers fall under FISA 702, are they electronic communication service providers? Can we rely more on Article 49 GDPR and stuff? Or can we use DLA Piper's amazing Wonder SCC assessment tool? But I mean, there might be other ideas out there. So, and this is why I want to wait a couple of weeks and see also where the market is going. This is also important for companies to understand, are we the only ones relying on Article 49 and all the other big tech companies are doing this or that? So this is also important to understand, where is the market going, where are the other big players going, do we have a robust solution, does it make sense, and yeah, what are the peers doing? This is also important for us.
Some feedback to that. Article 49 is in general not applicable to the public sector, but for private businesses, of course, it is one way of going forward. Another thing, so sort of getting back to the questions before, of course, this is a political thing. If you look at just the contracts, and the ECJ is clear that contracts is not enough. You have to measure in the politics and the law in the countries that are available. And in that sense, if we can hope that the US and the European Commission could maybe find some way going forward. But looking back, we have two things that makes this a bit. I'm a bit angry on this, to be blunt. When the Schrems one, when we had the safe harbor invalidated, there was a rush to get Privacy Shield up and running. And that process is not very pretty to look at, how it was done. And that is sad in a sense, because that was political will. So from a political perspective, they wanted to create something. And yes, that was good because that was needed. But what they created, sort of everyone knew from the beginning that this is not going to fly. This is just sort of a matter of time before this will be gone, it will be invalidated, which has just now happened. Like everyone predicted who read it from the beginning. And we also have proof that the European Commission has lobbied the US government to change FISA 702, to build in safeguards and be more public about sort of what the FISA requests are and how it works? Or could there be some kind of redress? Could a European citizen have standing in a US court in any shape or form? But the US government, when they renewed the FISA 702, I think it was in 2018, the last time. I think it's running to 2023, and I think they do it in 5-year cycles. But at that point, the US government said, no, we will just prolong the FISA 702 for 5 more years the way it is. So they didn't take the chance of doing anything from their side, and European Commission didn't really do anything from their side either. So to try to wish for political solutions from two parties that neither seem to be very interested in finding a solution that is workable in the long term makes me as a customer a bit, there is sort of the angry Daniel counts. Me as a customer, and also to all the companies like Anna is saying, you as a company are just hit by this, and that goes for all the other cloud providers and so forth. They're just victims of this, and we as customers are just victims of this as well. We've been relying on something that sort of, when the politicians say, use this is fine, this is legal, and then it isn't. And now we're all sitting here discussing what are we going to do now. We trusted the politicians to come up with a solution, but the solution was flawed from the beginning. So my hope for like a third decision here, I don't see how that is going to work, since FISA 702 is running to 2023 in its current shape anyway. How will any kind of sort of deal between the European Commission and the United States, how could a deal in any shape or form solve that issue? I find that hard.
I think it's a matter that companies and users probably should bark up the right tree, because it doesn't make sense to bark at the companies right now, because I mean, we can try to find a short-term solution with any additional clauses or rely on Article 49 GDPR. I totally agree with you. Probably the politicians should feel the pain, but this is a bit tricky, because if companies still try to find ways to find their ways with smart lawyers and outside counsel to find good additional clauses, this will take another year or years. And we might see another court case coming up saying, oh, now also SDCs are invalid. And I think, and this is what I try to do right now, try to find the right tree that I could bark up to and say, okay, in case European Commission doesn't help the business here in Europe, and US Department of Commerce doesn't help the US companies, we might see some heavy, business implications on this and that side of the pond. And not only business implications, also implications for society, maybe, because we cannot use as many, I mean, there's still communication tools we could use, and we can send letters again, and we send a carrier pigeon to send our messages from here to there. But I mean, this will also have an impact on society, and therefore I think the right tree to bark up to would be probably the politicians on this and that side of the pond.
I agree, and I would like to add that, I don't know, I'm pretty much with Professor Soliver on this, who and some other, I think the ACLU made some statements in the US as well, who said, is it really too much to demand that government mass surveillance can be challenged in an actual court of law? It seems to me personally that this is a matter of the rule of law. That government action can be challenged in a court, and to me personally, there would be one expectation for going forward, that these very, very basic, most basic in the European Court said, I think, essential parts of fundamental rights are in the very least better possible to be followed.
If I can,
go ahead, Ron.
Sorry, if I can add something, because we're always talking about 702 there, but there is other program and maybe even secret law we don't know in the US, and that's one of the basic principles of the Court of Justice assessment. I just would refer to a very, I think, a very important document of the Article 29, the new EDPB that was adopted in 2016, trying to assess the 4 fundamental essential guarantees that had to be respected when transferring data to the EU, to another country than the EU, and especially the US. And after the Schrems 1 judgment, the Article 29 made an assessment in 2016 with 4 fundamental guarantees that should be found in any instrument for transfer. The first one was an accessible law, and I think the court made it clear as well, not really that clear. The court in the judgment made it clear as well that US law on surveillance was not that accessible and not restricted enough to know what would be the limit of the law, which is one of the first requirements under EU law. The second was the judicial redress. And again, I don't see how contractual clauses and the BCR can provide a judicial redress for the EU citizen in the US. There is no way for EU citizen to challenge a decision of the surveillance authority in the US. There is a discrimination in the US system, not allowing the EU citizen to have access to a judicial redress. It's also up to the US to just open that as a human right and not as a right dedicated to the US. They have to open this right to the EU citizen. If they want to open their market to the EU, if they want to provide and open a gate for the market in the EU for the US provider, they have to change the law. In EU, we have to play by the rules provided by the EU legislators, and we don't accept that our citizens do not have a judicial redress in the US. And there was the third category, which was the oversight, and the last one, which was the massive and indiscriminate collection and processing of data. And this last point was also confirmed by the Court of Justice in the Schrems 2 decision as one of the key issue in this respect. So SCCs and BCRs and the new privacy shield or data protection umbrella is not going to change the massive surveillance of the US and the lack of judicial redress for EU citizens in the US. We have to also to explain that in the EU, a US citizen has the right to go to a DPA and has the right to data protection. It is not the case for EU citizens in the US, and that's a choice of the US government not to provide this right to the EU citizen. They cannot complain that you don't open the whole market of the US providers to the EU if you don't play by our rules. And I think it's fair enough. It's not a trade war. It's something which was already very clear in the Court of Justice judgment of 6 years ago. And I also wanted to add something that I just forgot, I think, of course. And I think I will remember it. Just to come back on this 702, just to mention there was also this Executive Order 12-333 that was also applicable for the transit of the data between the EU and the US. How do we solve this issue? With the Snowden revelation, we could prove that the NSA and the other surveillance community agencies were intercepting directly the transit of the data between the EU and the US. And it's not a question of visa application, and it's not a question of being in the scope of the visa, but also transiting merely information between the EU and the US. There is a huge problem there because the agencies were capable to intercept directly in the submarine cables the data transiting from the EU to the US, plus the other laws that we are not aware of because the US is not transparent about their surveillance laws. Whereas in EU, of course, it's a secret service. So secret service are secret. It's nothing new. It's the same in the US and the same in the EU. But at least in Europe, you know what the law allows you to do as a secret service or no. And then you do it secretly. But in the US, it seems that even the law is secret. So you don't even know what the law can do for you. And then it's also very difficult for the business to know whether they are subject to these secret laws or not, because they don't know them. So how do you expect a business to assess whether they will be subject to a law that they are not aware of? It's super difficult. But, and that's what I wanted to say, sorry, I'm quite long. I just want to remind as well, there is a special responsibility on the businesses, even in the BCRs and in the SCCs. I just want to remember that, I'm sure that Anna knows it. If you're aware that you're subject to a law like the visa law, you have to notify the DPA and you have to notify the exporters in the EU. Does the business do that, know that, or notify? I'm not sure, but it's an obligation under the SEC and the Privacy Shield.
Yeah.
And if they are not doing that, there is also another, and let me look at my, of course, thought behind what I'm saying. There is also a judicial redress for the data subject to claim for damages to the business importer and exporter if they are not notifying the exporter of their surveillance law, to which they are subject. So there is also an obligation. It's not only in the Privacy Shield, it's also in the SCCs and in the BCRs. They have to notify the DPA that they are subject to surveillance laws. So even if Microsoft is using the SCC, they have to notify the DPA that they are subject to a FISA subpoena, whatever you want to call it. And it's also very clear in the SCC, and we heard it a lot of time, that SCC are not just a contract that you can sign and put in the drawer. You have to read it and execute it and provide the judicial redress and the rights that are provided in this contract. Not just put it in the drawer and just consider that the transfer is compliant. You have to make it available to the citizen and to the exporters, and they have the right to ask for compensation if the exporter or the importer is not compliant with these contractual clauses.
So that's a great, that's a great segue into our next question, actually, and maybe I'll direct this one at Anna. In light of the US global surveillance powers, do you think they could also impact trade secrets under the 2016 EU directive, which was 2016 of 943, I believe?
Maybe, I don't know, I think we have only a minute left, and maybe to wrap it up, I don't know if you have time, Anna, maybe more in line with previous, would you like to say something on Brexit as well, or instead?
Let's focus more on Brexit. I have the impression that we all don't know yet what this court ruling, what kind of implication it has on Brexit as well. Mm-hmm. Because we all know that the UK is part of the Five Eyes agreement, and Canada as well. So maybe that has also implications on the Canadian adequacy. So I think, to wrap it up, I would recommend buy even more popcorn, because there will be a lot of discussions and very interesting developments. And this is what I really appreciate and like in the privacy field. It's so agile. It's so every week something new. And it's a very nice, interesting global community where you learn a lot and have a lot of diverse players with different interests. But overall, I think that to wrap it up with a good note, there will be a lot of job security for privacy professionals in the next coming years. And I appreciated the discussion a lot. Thank you.
Dennis, maybe you want to take some closing notes on what's the ideal way to go, why, and what's realistic to happen. Probably. Dennis, you're on mute. I think you'll have to unmute yourself.
Yes, thank you. I guess for me, it's more of a summary of this discussion, right? I think we really focused quite well on what are the issues, what are possible solutions. I think we know it's not going to be easy. It's not going to be possible for, especially or for companies, and even more difficult apparently for government institutions to find ideal solutions. So our job as privacy professionals will be to do the best that we can and make the most out of the instruments we have available. Yes, one thing I learned personally is that we will need to buy popcorn, and we will need to have patience. I believe we will need to have a stamina, and there will be lots of discussions for a while, and lots of gray zones, lots of work. Yes, I'm really excited, and thank everybody for very inspiring and excellent comments. And I think it would be wonderful if we had yesterday, a huge revision of US surveillance law. I think, to be honest, most US privacy professionals would also love that. I think US citizens would be happy to be able to go to court. It would also be perfect then to have a EU Commission adequacy decision, which is completely in line with EU fundamental laws, where the ECJ was actually, in my view, didn't oppose another on the US our standards, but said sort of this is the minimum that the EU requires for an adequacy. It's not sort of ideal. It's not what the EU. It's not the GDPR standard. Yes, I think California Privacy Shield would be an interesting idea. I'm not sure it fixes the visa issue, and I think these issues will keep us very busy right now. And I think one of the really important things, Anna had some wonderful suggestions about the visa notification requirement, for example. And if you don't find a way to solve it, at least the DPIA informing the relevant parties maybe. And also for people who didn't yet, make sure you do contact a privacy professional. Do ask an attorney to at least know what risks you're getting yourself into and what are some things you may be able to do, at least to try and remediate some of the issues. So thank you so much for everybody for your time. Sorry, I think I was a little over time already. And I will stop now. Thank everybody for coming, and especially our panel. Excellent points. It was a great pleasure to discuss with you.
Thank you to all our speakers.
Thank you for the invite.
Thank you.
Thank you.
Bye.
Thank you to the Berkeley Global Society. It's been an amazing discussion here. I think we have a lot of takeaways, especially for our dear friends and colleagues who are studying right now, and they're maybe confused about what they should be majoring